Hello and welcome to CJJ's webinar on Gault at 50, Ensuring Counsel for LGBTQ Youth in the Juvenile Justice System. My name is Katie Mercier and I'm CJJ's Senior Associate for Conferences and Membership. I wanted to take a few minutes to run through a few technical details before we begin. First, you'll notice that all participants are in listen-only mode, which means that you are muted throughout the webinar. We will take questions at the end of the presentation, and you can ask a question in one of two ways. First, you can type your question into the questions box at any time throughout the presentation, or during the Q&A session, you can click the Raise Your Hand button. I'll then call on you, unmute you, and you can ask your questions verbally. I do ask that if you're on a cell phone that you use the questions box so that we'll avoid any audio feedback. We will be recording this webinar, and the recording and the PowerPoint will be posted on CJJ's website within 24 hours. And with that, I'd like to turn over the webinar to today's moderator, Lisa Pilnick, who will introduce our speakers.
Hi, everyone, and thank you, Katie. So I'm really excited about this webinar for a couple of reasons, but really the biggest reason is that it allows us to address two really important topics in the field together. So CJJ and the partners that you're going to hear from today have all done a lot of work on the issue of LGBTQ youth in the juvenile justice system, and we try to highlight that issue in general, but especially this month with June being Pride Month, we wanted to make sure that we were including a focus this month, and so we squeaked it in just before the end of June for Pride Month. And then last month, as many of you know, the National Juvenile Defender Center launched their Gault at 50 campaign, which focuses on the importance of counsel in juvenile delinquency cases. And so we really wanted to be able to share the information about that launch and about that issue with the field. And so I'm really excited that we're able to address both of those issues together in this webinar today. I'm going to do a quick introduction of our speakers, but I also want to just take a moment to thank them so much for sharing their expertise with all of you. So I'm going to go over, I'm going to introduce the speakers in the order in which they're going to speak rather than the order that you see them on your screen, just to help you have a sense of who's speaking when. So Naomi Goldberg leads the Movement Advancement Project's Policy and Movement Research. She joined in 2010 after completing a public policy fellowship at the Williams Institute at the UCLA School of Law. Her work has focused on LGBT families, LGBT older adults, and economic security for LGBT people. And I apologize, I said I was going to introduce them in order, but Naomi is actually speaking second today. Our first speaker today is Christina Gilbert, who became staff attorney and policy counsel at the National Juvenile Defender Center in 2016, after initially joining the organization in 2012 to direct the Equity Project, which provided training and technical assistance to enhance policies and practices related to sexual orientation, gender identity, and gender expression. In 2015, she also took over managing a national organizing campaign housed at NJDC, seeking to amend state laws, court rules, policies, and practices that permit the automatic shackling of children in delinquency court. Laura Austin is a supervising attorney in the juvenile department at the Office of the Ohio Public Defender, where she oversees the juvenile department's reentry trial, intake, and conditions of confinement work. Prior to entering the practice of law, she worked in the mental health field for 7 years. She is certified by the Department of Justice as a Prison Rape Elimination Act, or PREA, auditor for both adult and juvenile facilities. Just to give you a quick roadmap of what to expect over the next hour, Christina is going to start us off by talking about the Gault at 50 campaign and the importance of counsel in juvenile delinquency cases. Naomi is going to share research that was collected in a recent Movement Advancement Project report on LGBT youth and the juvenile justice system. And then Laura is going to help pull all of it together and talk to us about what this means for LGBTQ youth in juvenile delinquency proceedings. And she's going to share a bunch of great tips, which will be helpful if you're a public defender, but really are also very applicable no matter where you are within the system. So I want to once again thank each of these terrific speakers for joining us today and turn it over to Christina.
Thanks, Lisa. Yeah, so like Lisa said, you heard Lisa and Katie mention the Gault at 50 campaign from the National Juvenile Defender Center, so I'm going to talk about that. But first, before we talk about the campaign, I'm going to talk about what Gault is. Next slide. And you can actually just go to the next one, too. So what is In-Right Gault? The Gault at 50 campaign is based on a Supreme Court decision that next May will be, in May of 2017, will be 50 years old. And basically, the Supreme Court said that children have a right to counsel, so a right to an attorney in delinquency proceedings, just like adults do, and they said that is a constitutional right. So what happened in Gault? In 1967, 15-year-old Jerry Gault was sentenced to serve nearly 6 years in a state industrial school for allegedly making a prank phone call. After he made the phone call, he was taken into police custody without his parents being notified of his arrest. Jerry reportedly confessed to the crime without a lawyer or his parents present. He was not advised of his right to silence, his right to be represented by an attorney, or the state's obligation to provide him an attorney if his family could not afford one. He appealed, and the case made its way to the Supreme Court, where they determined that his trial violated his right to due process, which every citizen, including a child, is guaranteed. So as in re Gault, the case came to be known, it transformed really loose juvenile court proceedings into more formal hearings that afforded children essential rights. These rights, especially the right to an attorney, are the cornerstones of what we see as a fair juvenile justice system. So now here we are nearly 50 years later, and many places around the country, children continue to stand alone in court, or they don't have true meaningful access to counsel, even if there's somebody standing next to him or her. And so that's where we're focusing on the Gault at 50 campaign, but I just wanted to provide that context of kind of what the Gault decision was about. Next slide. And Justice Abe Fortas, this is just a great quote from the decision. There are many, there's great language, and I encourage you all to read the case. 387 U.S. 1 is the citation. The juvenile needs the assistance of counsel to cope with problems of law, to make skilled inquiry into the facts, to insist upon regularity of proceedings, and to ascertain whether he has a defense and to prepare and submit it. And so this is just really recognizing that a young person facing the deprivation of liberty and of their rights needs the guiding hand of counsel. Next slide. Nearly 1 million children are charged with crimes in delinquency court annually, which is just a staggering number. You know, it's not in these slides, but the United States also incarcerates more children than any other nation in the world. Next slide. So, I mean, we just said that the Supreme Court and the Constitution say that kids need lawyers, but then the question is, do they really need an attorney? And I'm going to say yes, emphatically. Access to counsel for children means more than just representation in court. So what does having a juvenile defense attorney really mean? To us at NJDC, what that means is we believe in juvenile defense as specialization, that juvenile defense attorneys need to know everything that any criminal defense attorney would know and represent their clients to the fullest extent possible, zealously advocating for them. But they also have to know a lot of other things. They have to know about adolescent development. They have to know about all the collateral consequences a young person might face. They have to know about family and school and community. And then we also believe in holistic advocacy. And so that's what I mean when I say it's more than just standing up in court. We really believe, and I'll talk about this a little more when we talk about the campaign, but that true meaningful access to counsel requires a juvenile defense attorney to be appointed at the earliest moment possible and to represent a young person throughout the entirety of their case. So that includes, you know, during disposition, helping with disposition planning, if they are going to be adjudicated delinquent, as well as post-disposition advocacy. Next slide. So this is just in addition to holistic advocacy and going back to what I said about that a juvenile defense attorney has to represent their client the same way an adult defense attorney would, is that the role of a juvenile defense attorney is different than that of any other stakeholder in the system. All other stakeholders in the system have a best interest role. Defense attorneys must represent the stated interest or the expressed interest of their client, of what their clients want, and that includes youth clients. Now, that doesn't mean that they should not counsel their clients, their youth clients, on what might or might not be in their best interests. We have an ethical obligation to advise and counsel our clients. However, at the end of the day, no matter what, the juvenile defense attorney has an ethical obligation to represent the expressed or stated interests of the clients, and I think this is important for all youth. But I think in particular with LGBT youth, but really any youth, we can't make assumptions about what those expressed or stated interests are without doing that holistic advocacy, really listening to our clients, getting to know them, taking the time, as well as looking at all of those other pieces related to a young person's life and their system. Next slide. So what led us to the Gault at 50 campaign? So there's clearly a crisis. NJDC does assessments of juvenile indigent defense across the country, and even though 50 years ago, almost 49 years ago, the Supreme Court said that children have a constitutional right to an attorney in delinquency, we see kids either not having an attorney or waiving their right to counsel without fully understanding what that means all over the country. We also see inadequate juvenile defense delivery systems. There are real disparities around the country about how both public defense and juvenile defense systems are allocated. In some places there are statewide systems, in some places it's countywide. Juvenile defense often does not, I mean, there's a major indigent defense crisis even within the adult system, but even compared to that, juvenile defense in many places does not get the same resources, whether that's funding or access to social workers or investigators. And then practice is inconsistent with adolescent development. We also see just a lack of understanding, even since Gault. Much more recently, the Supreme Court has recognized in a number of cases, from Roper through Graham and Miller and Montgomery, has recognized that children are different and looked at the research about the adolescent development and the adolescent brain, recognizing that the juvenile justice system is designed to be rehabilitative. It should be treated differently because of all of this research. And it also just, finally, the crisis is that there's a misperception often that, oh, well, it's just kiddie court, or that things don't matter as much. It's not as big a deal. We don't have to put as many resources there because everything will just get sealed and it won't matter. But what we know is that that's not true, is that there are real serious collateral consequences to having a juvenile record and to being system involved as a young person. Next slide. So 31 states have no laws declaring how young is too young to prosecute a child, which means, you know, I was just at a training last week, and I think the youngest, with a bunch of defense attorneys, and the youngest I heard about was a woman who had a 6-year-old client. And so I think these are really just all different pieces of the crisis that we need to take a serious look at. Next slide. So the Gault at 50 campaign. So what is the Gault at 50 campaign? One of the goals, the main goal of the campaign between now and May of 2017 is to raise public awareness about this crisis and to educate the public on what we can do about it. What you see here are the campaign statement of principles, and these were developed in collaboration with juvenile defense attorneys and other stakeholders around the country. And really what we believe is that, one, all children should be provided a juvenile defense attorney at the earliest possible moment. You know, ideally that would be at the moment of arrest, but at the very least it does not mean an attorney meets their client for the first time 30 seconds before a detention hearing and has no time to talk to them before walking into the court. We believe that all children should be automatically eligible for a publicly funded juvenile defense attorney, and so we believe that a parent's income should not be the factor determining whether a child gets a public defender or not. Children can't work, and so they don't have money. And in addition, in many states, indigence determinations can draw the process out. They can be very complicated and lengthy, and they may cause conflict between the child and the parent relevant to the case. A child's juvenile defense attorney should represent them throughout the entire process, and so this goes back to that point about holistic advocacy, is that it's not just for that one court hearing that they show up and then leave, but they're really there early on. They represent the client through their whole process. They help with dispositioning planning. They help make sure they understand any conditions of probation. They can address any conditions of confinement issues. They are aware of reentry services in the community, and just to really look at all of those pieces. Specialization. We believe that juvenile defense attorneys need specialized training to represent children, that it's, you know, really, in addition to being a criminal defense attorney, you have to understand young people and the juvenile justice system. And then we all need to support publicly funded defense systems. They need the training and the resources and the funding to ensure specialization in juvenile defense and that access to counsel for youth is meaningful. Next slide. So this is just, I want to encourage everyone to go to Gault, G-A-U-L-T, at 50.org. This is where we have everything about the campaign, and between now and May of 2017, we will have events up there. We have monthly themes, like this one, which was focused on pride and LGBT youth with social media toolkits, and all sorts of different ways you can get engaged and use the tools to connect it to your work. And then we encourage anyone, either your organization or you individually, to endorse the statement of principles. So you can go to, on the left-hand side on the tab of the website, if you go to Get Involved, you can endorse the statement of principles there. And then after May of 2017, we will continue with the campaign, but we'll really be focusing more on the policy reforms to implement all of those different pieces of the statement of principles. Next slide. Again, just a little more information about the campaign. Next slide, and our social media. And this is the website right here. So with that, I just want to say thank you so much. So that's kind of a general overview of Gault and Gault at 50. And I'm really excited to work with Laura and Naomi. Naomi is now going to tie the general principles around access to counsel in Gault and what has happened with LGBT youth in the juvenile justice system and the research that we've had since then. Thanks so much.
Thanks, Christina, and thank you to Lisa and Katie at the Coalition for Juvenile Justice for hosting. My name is Naomi, and I work for the Movement Advancement Project, and I'm excited to be speaking with you all today. I'm going to focus my presentation, as Christina mentioned, on what we know about LGBT youth in the juvenile justice system, because I think it has really important connections to why access to counsel and the campaign Gault at 50 are so crucial, specifically for LGBT youth. I'm going to be using the term LGBT today to refer to individuals who identify as lesbian, gay, bisexual, and/or transgender. These are terms that some people use to describe their sexual orientation or gender identity. It's important to note, particularly when working with youth, that many youth may use the term queer, which can be used to describe someone's sexual orientation and/or gender identity. So you'll frequently see in the youth context, in particular, the acronym LGBTQ. And I'm probably going to bounce back and forth between the two, but I wanted to make sure we're on the same page about terminology before going any farther. Next slide, please. As Lisa mentioned during her opening remarks, the Movement Advancement Project is where I work, and it's an LGBT think tank. In February, we and the Center for American Progress released a lead report in a series focused on LGBT people and the criminal justice system. We partnered with the Advancement Project, Forward Together, and Just Leadership USA. Subsequent reports in the series include a focus on transgender people, girls in the juvenile justice system specifically, communities of color, and LGBTQ youth. You can find this report, more detailed discussions of some of the topics I'll be discussing today, and more at the link here to our website. Next slide. In our report, we focus on three broad topics which comprise a cycle. First, what pushes LGBT people and youth into the criminal and juvenile justice systems? Then, how they are treated within the justice system. And finally, what challenges LGBT people face once they are released. I will spend some time in a few minutes talking about some of the key issues for LGBT youth and their engagement with the juvenile and criminal justice systems. But first, let's take a poll. When we talk about LGBT youth in the juvenile justice system, I'd like you to think about what % of youth in the juvenile detention facilities do you think identify as LGBTQ? Data about LGBT people in general is lacking across this country, and particularly in the youth sphere. So the best estimate that we have is that 7 to 9% of youth in the general population identify as LGBT. But what about in juvenile and criminal justice systems? There are approximately 3.2 million LGBT youth across the country, and research from the Williams Institute estimates that about half are at risk for arrest or entering the juvenile and criminal justice systems. Angela Irvine at Impact Justice is a leading researcher about LGBT youth and the criminal and juvenile justice systems. And if we switch to the next slide, we can see some of the findings from her research. Her research, particularly on the far right, from 7 juvenile justice facilities in the United States across the country, found that 20% of youth in these facilities identified as LGBT or gender nonconforming. What's even more shocking is that when you look at girls specifically, the number jumps to 40%. And while we know that many youth in juvenile detention facilities are youth of color generally, nearly all LGBT youth and gender nonconforming youth in the facilities Dr. Irvine surveyed were youth of color. Specifically, 85% of LGBT and gender nonconforming youth were youth of color. Now these numbers may or may not be surprising to you, but they do beg the question why. Why are LGBT youth so overrepresented in these facilities? Next slide, please. As I mentioned earlier, MAP's report examines what forces push LGBT people and youth into the criminal and juvenile justice systems. I don't want to spend too much time here, but a few important points I want to make are about the topics highlighted in green on this slide. When LGBT youth are disconnected from their families, they may enter the child welfare system, and crossover between the child welfare system and juvenile justice systems are high. Unsafe schools and the school-to-prison pipeline push LGBT youth, particularly LGBT youth of color, into the system. LGBT youth may be disciplined at increased rates. They can experience high rates of harassment and bullying, all of which may result in skipping class or dropping out entirely, which puts them at risk for interactions around truancy and later system involvement. LGBT youth are also overrepresented among youth experiencing homelessness, and those youth are at increased risk for involvement with police and systems through survival work, whether it's trading sex or drugs or petty theft. You can read more in our report, but there's evidence showing that police profiling, stop and frisk, and other policing tactics also impact LGBT youth, particularly LGBT youth of color. Data from a national population-based survey found that LGBTQ youth were as much as 300% more likely than their non-LGBT peers to experience some official sanctioning, whether being expelled from school, being stopped by a police officer, arrested, adjudicated, or convicted as a juvenile or adult. So the next slide shows some data to support the points I just made. You see on this slide that 40% of LGBTQ youth in California detention centers were held for running away, compared to just 13% of non-LGBTQ identified youth. Again, unsupportive family situations, unsafe child welfare settings, all of these can be reasons youth run away from home. And on the next slide, we see that the rates broken down by gender for boys and girls. And you see here higher rates of detention for running away for girls, 38%, and 28% for LGBT boys compared to their peers. Now for many of you, all these factors that push LGBT youth into the system are important, but the real question for you as attorneys and advocates representing youth is what are their experiences in the system and how can you provide effective counsel? On the next slide, we break out the places where LGBT people and youth, highlighted again in the green boxes, have negative experiences in the justice and detention systems. Judges, prosecutors, and court staff may have a limited understanding of what it means to be LGBT. Youth share stories of people using, or court staff and judges, using the wrong pronoun or name, of being held because they skipped school, but because they'd done so because school wasn't a safe place for them, or where family failed to advocate for them because they don't approve of their gender identity. In a survey of youth in Louisiana, 50% of gay youth arrested for nonviolent offenses were held awaiting trial, compared to fewer than 10% of their non-gay peers. And we know from broader research that youth of color are much more likely to be held while awaiting adjudication. In detention settings and juvenile confinement facilities, LGBT youth face a number of challenges, including improper placement, where trans youth may be placed in a facility in accordance with their sex assigned at birth rather than their gender identity. LGBT youth experience high rates of harassment and assault by staff and other youth. New analysis from the Bureau of Justice Statistics about the experiences of LGBT youth in facilities, actually one just released yesterday, finds that LGB youth were more than 7 times as likely than heterosexual youth to be assaulted by another youth. 1 in 10 LGBT youth had been assaulted by another youth compared to just 1% of heterosexual youth. And that study also found that LGBT youth are more likely to have histories of prior sexual assault. Access to competent medical care is also crucial for LGBT youth, particularly trans youth, and some facilities may rely on faith-based programs to provide counseling or push youth into so-called conversion therapies, which could be particularly damaging to LGBT youth. There are issues around basic needs, including access to gender-appropriate clothing, to visitation policies. Youth may or may not be out to their families, and that can present challenges when they visit or when a youth is being prepared for release. When plans are made for returning home, to schools, and to communities, these plans may not take into consideration a youth's experience as LGBT, or whether there are necessary supports. I think for you all as advocates for youth, LGBT youth, these are important issues to keep in mind. And I'm happy to share more about these issues and what we know during our time for questions, but I think Laura is going to start talking about how some of these issues play out for attorneys and what you all can do to help advocate for LGBT youth in the juvenile justice system.
Thank you, Naomi, and thank you to the Coalition for Juvenile Justice and certainly to the National Juvenile Defender Center for organizing this webinar. The first couple of slides I have, slide please, are really just to reinforce the importance of having highly skilled, trained, and qualified attorneys for juveniles. As Christina mentioned, juvenile court should not be a means by which to train attorneys to represent adults. Juvenile law is absolutely a specialization. And it's important for a couple of reasons to have highly skilled and trained attorneys representing kids. First and foremost is, just like an adult, they're entitled to due process. They should be represented and have someone who's competent in that area of the law to represent their stated interest and to defend them. And it's important to keep in mind that juvenile court is not only rehabilitative in nature, but also includes punishment and potential lifelong sanctions. When we're talking about kids in certain jurisdictions where sex offender classification and registration extends well beyond the age of minority, well into their adulthood, that's a lifelong pretty damning sanction that they're going to have to deal with when we're talking about kids who have offenses that may not be able to be sealed or expunged. And so we're talking about long-term consequences, not just something that's going to end at age 18 or 21. And so it's important to have qualified counsel. It's also important, I believe, to have an attorney who is going to fully represent a kid when we think about procedural justice. This concept or idea that folks who are involved with the justice system are more amenable or accepting of the outcome if they feel that they've been treated fairly. So for a kid, if they feel like they only had an attorney for 5 minutes before a hearing and that nobody in the courtroom really heard them out and no one spoke on their behalf or paid them much attention, regardless of the outcome, whether it went their way or not, they may not feel that they were treated fairly. Whereas if a kid, let's say, has a poor outcome or an outcome that's not in their favor in court, let's say they get sent to detention, they may feel that the process was fair if they had an attorney by their side to carefully and meticulously explain the process and what's happening, the possible consequences, and ways in which that attorney can advocate for the child's stated interest. And so on a couple of levels, it's very important that we have skilled and trained lawyers who are very well aware of how to deal with kids and that particular area of the law. Next slide, please. And when we're talking about effective representation for kids, the first step is you've got to have a good working relationship with the client. And you know, Christina mentioned that juvenile defense attorneys should be representing a kid's stated or expressed interest, and that we're not there for a best interest perspective. And I think it's always interesting to think about in another area or profession, if you represented or if you worked for a 15-year-old. So let's say I'm a contractor and I build houses. Can you imagine building a house for the stated specs of a 15-year-old? You know, I might have 2 swimming pools, a basketball court, and a video game room, but we would have skipped the laundry room. And so it's a very interesting and unique idea that you literally work for a juvenile. And in doing that, it's important to be able to have communication skills that you can make sure that the juvenile kid is informed about what's going on, that you can gather information from them, and trust is imperative in gathering information from a client. For the juvenile defense attorneys out there, I'm sure you're aware of a situation in which you've gone to talk to a kid about an offense that they've been accused of committing, and you want to get the story, you want to get their side. Well, what happened? And they'll tell you the beginning of the story, well, I was sitting on a park bench. And then they'll tell you the end of the story, and then I was arrested. But they'll skip the middle, and it's about that line of communication that kids haven't yet developed, and perhaps for some of our kids who have cognitive delays or mental health issues, they may always be a bit behind on, even into adulthood. And so it's important to be able to garner information from our clients and to be able to communicate with them on a level that they can get the information to us that we need to represent them. And so in establishing trust, and I'm kind of covering big ideas right now, but on the next slide I'm going to move to very specific recommendations that I hope will help you on this. But you've got to be aware, before I move into the slide, you've got to be aware of any biases you might have. And so I would encourage you to look for in your community, or perhaps even on the internet, if you don't have one in your community, trainings on implicit bias. Even the best of us may have biases in the work that we do. And so it's important that we're aware of them and that we know how we can address them and work around them and work through them. And so, when we talk about implicit bias, I think sometimes folks, the first thing that comes to mind perhaps would be race or ethnicity. But also it could include kids or adults that identify as lesbian, gay, bisexual, or transgender. And so I would encourage you to put that on your list of things for your agency or your division to consider in this next coming year. So to recommendations. Common practice recommendation I usually start with is, when you introduce yourself to a child, to your client, ask them what name they like to go by. For the past 5 or 6 years, I've worked in a capacity where I routinely provide an intake service to kids who are entering the Department of Youth Services. And so, on any given day, I might have 5, 10 kids, depending on the day, that I'm going to meet with. And so I'll call their name to come back to my office to meet with them. But one of the first things I do is I don't call them Mr. or Mrs. I don't, attach a pronoun to them. I say, what do you like to go by? I think that does 2 things. One, it provides a space in which they can tell me some information about themselves. Perhaps if they identify as gender nonconforming, or if they identify as gay or bisexual, they might offer up that information through the names that they like to be called. But it also communicates to a kid that they are important. It matters to you what they like to be called. And I don't know that they always hear that. A lot of times when they are shuffled through the system, they're called by their last name or first name or by a number, but rarely are they asked what they like to be called. And so I think it's an important first step. Second, if you have questions during your interview, maybe you're not dealing with kids who are locked up yet. Maybe you're dealing with a setting in which you're trying to avoid detention, and so you're quickly trying to gather information. And even in those settings, you may have questions about, hey, who lives in your home? Who could we get you released to today? Who might be able to care for you? And in doing those questions, I think even small steps can communicate to a kid that it is safe and that you are accepting of their sexual orientation or gender identity if it's relevant. And so I encourage you, if you say, who lives in your home? Not to say, do you have a mom or a dad? Or do you live with, a boyfriend or a girlfriend, depending on the sex of the client you have, but to say, and to put it out there. If I'm talking to a male client, I might say, all right, well, do you have a boyfriend or a girlfriend? I'll just put the option out there, and then they might feel safe in communicating that. And it also works. I can distinctly remember a young man I was talking to, and early on in the interview, I asked, well, do you have a boyfriend or a girlfriend? And he said no, and then later on in the interview, I needed to move towards asking who lived in his home. And he said something about his mom, and I said, well, does your mom have a girlfriend or a boyfriend or a significant other? And then the young man shared that his mother was gay and that she had a partner, and it became an important part of the conversation. It related to where he would prefer to live upon release. And so taking those things into account and making sure in small ways, next slide please, that we're being mindful of our clients and their situations. Obviously, interview settings are crucial. If we're talking to kids out in a hallway of a crowded courtroom or near other youth in a facility, I don't know how comfortable I would be sharing personal information, let alone a child who may feel very isolated. And so to take whatever means and steps we can to reserve a space that allows the child to communicate information to you in a confidential setting, outside the presence of parents or guardians, outside the presence of peers in a facility, that you get a quiet space and that you get time. And if you have a space if you have the luxury of having an office or a space where you routinely meet with kids and they come to you, I would encourage you to consider offering information about resources or even supportive signs. And I have offices in a couple of facilities in my state, and in those offices we display little posters from the American Bar Association that talk about this is a safe space, and it has a rainbow picture on it. And so if nothing else, the kids see that and they take note, and hopefully it's another level of communication that we can have with them about it being a safe space. I would encourage you to know the PREA standards, the Prison Rape Elimination Act standards, and I would draw your attention to, for juveniles, for youth, standard 115.331. It's one of the first ones, and it talks about employee training. And if you go to Category 9, the standard says that the agency shall train all employees who may have contact with residents on, number 9, how to communicate effectively and professionally with residents, including lesbian, gay, bisexual, transgender, intersex, or gender nonconforming residents. And why it's important, you may say, well, the facility I'm dealing with, the PREA doesn't apply to them, or my state isn't, planning on being compliant with PREA, or, there may be a litany of reasons why you think PREA doesn't come into play in your practice. But I would encourage you to rethink that, because when we're talking about kids being confined away from home, it's important. We should know our client better than anybody else, and it is important that we understand the facilities they are being placed in, and that we understand whether or not they are meeting PREA standards. And if they are, then we can advocate that our clients would go there in lieu of other facilities that may not be as qualified or as trained. And if we run into facilities that unfortunately may not be meeting PREA standards, that we would bring that to the attention to the court. Certainly the court is charged and has a duty to certainly be aware of where they're sending kids, but as an attorney, you need to advocate for your client. And so I would encourage you to be mindful of that. And if you, God forbid, find a situation where a kid is in a facility where they aren't being compliant with PREA, that you could bring it to the attention of the court and to the facility and cite directly to the PREA standards. And there are several others that deal directly with LGBT issues, but I would encourage you to know that your client should be treated respectfully and communicated with professionally in those facilities. Next slide, please. And so if you get to a point in an interview or an interaction with a client where they discuss their sexual orientation or their gender identity, it is really important that you are clear with them on if or when that information may be shared. Just like anything else with a client, when we're representing stated and expressed interest, we're very careful about who we share information with and that we have releases of information. But even in conversation with the state or perhaps a children's services caseworker or a parent, if you aren't double and triple checking with a kid what information they want shared or what information they have already shared with other folks, you may run the risk of divulging information that they wouldn't otherwise want shared and really affecting their relationship with a parent or another caregiver. And so what I often like to do, and I'm sure many of you do it, is when I'm communicating with a kid, if they share a piece of information with me, I'll say, all right, this is what I understand that you understood that you have said, and then I'll kind of pair it back to them what it is and make sure that I've understood first the information correctly. Then I'll review, well, how is that relevant or perhaps not relevant to the case at hand? And then lastly, I will review with them, all right, in what ways, if this is relevant, do you want me to share this information? And I'm very clear to empower the client that they know that they're driving the boat here, that they're driving this, and that they are the ones that are going to dictate how I'm going to share this information. And to repeat it back to them. And if a few days or a few weeks pass before the next proceeding or before the next time I have an interaction with them, I'll often double check. We know our kids all too well. They change their mind every few minutes, let alone every few proceedings. And so to double check that information is still safe with them to share with the court or others. And that kind of touches on point number 7, that if information is relevant to a juvenile court proceeding, that you may want to consider ways in which you don't have to share that in open court. I could think of a young person that I represented that had a parent with a very bad addiction issue. It just, the parents struggled, and it really impacted both my client and her siblings. And it was a very sensitive topic for this young person, and she didn't want it shared. Like many of our kids, despite how they are perhaps treated in the home, they are extremely loyal to their family, and this particular client was, and she didn't want me to share in open court the issue. And so we I requested a meeting in chambers, and it was okay with the client that I shared it with the state and with the judge, but she just didn't want it said in open court where perhaps other people might hear it. And so to take that into account, you know, you may want to clear with your client a couple different options and to be able to present them. Because, you know, if you're dealing with a client and you say, all right, you don't want me to say in open court, well, how would I, you know, where would you prefer I say it? They have very little experience with the system and their options, and so to be sure to present them with options or alternatives. Next slide, please. And so, again, just reinforcing that we're very clear on when that information might be shared, what, you know, getting their permission repeatedly, making sure that you're communicating it in a couple of different ways. Also, identifying resources in your community that clients can access to discuss feelings and support and find support. We have a duty as attorneys to counsel our clients and to provide them information, and that includes, you know, if I'm representing a kid on an aggravated robbery and perhaps their sexual orientation or gender identity isn't directly related to the offense or the case that I'm representing them on, but if they bring it to my attention that they're struggling with the issue or they want more information, when we talk about holistically representing young people, we certainly have a duty to help them get that information and to be able to have access to those resources. Next slide, please. And so, you know, in more drastic situations when we talk about kids who are homeless, who've perhaps been kicked out of their home or been forced out of their home as a result of their sexual orientation or gender identity, having ready information on shelters or other places where they can find care and they can find housing. And I would encourage you, you know, you're going through law school or you're going through different trainings, or, you know, we're talking about issue spotting. Be aware of issues or offenses that might signal or indicate that a kid is struggling because of their sexual orientation or gender identity. And I know Naomi mentioned it, and I believe Christina did as well, when we're talking about survival offenses. You know, if a kid is constantly running away, could it be that they're a kid and they just don't have someone at home setting boundaries, perhaps? Could it be that they are struggling with sexual orientation or gender identity and that's a cause of friction or you know, trouble at home? Perhaps. And so to offer that up, you know, when you're talking to your client saying, all right, well, is there a problem with the folks in the home? Is, you know, are you just don't like it there? Is someone hurting you? Is someone not treating you well? I oftentimes will put it out there. You know, do you or someone else in your home, do you have trouble with sexual orientation or gender identity as far as communicating that? Offering it up, because I think it's oftentimes easier if someone is offering a multiple choice question as opposed to an open-ended question. And just to be aware generally of the message that you communicate. When we're standing in the halls of the juvenile court, when we're you know, in our office, perhaps in the lobby, that we are always mindful of the perception that kids have. How many times has a client perhaps said to you that they feel like you're friends with the prosecutor? Well, now you may work with the prosecutor day in and day out, and certainly we need to be civil and appropriate in our interactions with the state. And perhaps it had nothing to do with the case, but maybe you were sharing a joke or a laugh with the state, and now the kids got it in their head that you're friends with the state, the prosecutor, and that you're not there for their stated interest or to represent them. And so likewise, if you're in a situation where perhaps someone tells an offhanded joke or remark that deals with certainly anything, LGBT included, but also race or ethnicity, I think we have an absolute duty to correct the party who has said the offhanded remark and to make it clear that we don't find it appropriate. If for no other reason that our clients may be listening and may be hearing us, and we need to set the standard that we are accepting and that we are supportive and that we won't tolerate inappropriate comments or behavior about persons who identify as LGBT. And so I hope that those are just a few steps, some recommendations that might help you in your everyday practice. At the State Public Defender in Ohio, we are always more than welcome to brainstorm and to talk through situations in our own state and in other states. And so if you ever have questions about ways in which you might be able to address a certain situation, we are always open for a phone call or an email. And at this time, I'm going to turn it back over to Katie so we can perhaps take some questions. Thank you.
Okay, thanks everyone. At this time we'll do a Q&A. Just as a reminder for those who weren't here at the beginning, you can ask a question in one of two ways. You can either type it into the questions box and I can read it aloud, or you can click the raise your hand button and I can call on you, unmute you, and you can ask your question verbally. I do ask if you're on a cell phone that you use the questions box so that we can avoid any audio feedback issues. While I take a minute to let everyone type their questions in, I just wanted to point out that we have all the speakers' contact information if you have a question and we don't get to it in the next few minutes. You can certainly contact them directly. If you require a certificate of completion, you can just shoot me an email. So for now, we have our first question is, do you have any recommendations for juvenile probation officers in dealing with the LGBTQ population?
This is Christina. I mean, I can answer. I'm sure everyone else has other information to add. But I would say I think everything that Laura just said, all of her recommendations, I think are applicable to every stakeholder within the system. I think that, you know, we through the Equity Project worked very closely with a couple of probation departments around the country. I think it's really important that probation officers all have training on working with LGBT youth in the juvenile justice system, that they have policies. There are lots of model policies out there. The Santa Clara County Probation Department has one of the most comprehensive that covers everything from general non-discrimination provisions to required training, required ongoing training, to housing of transgender youth. And you know, it depends if you're talking about probation officers that work in the facility or in communities. The housing piece might not be as applicable if it's in communities. I think one really key issue that I have heard anecdotally around probation working with LGBT youth, in addition to just kind of the general information Laura shared, is that I think that, and this is true of a lot of conditions of probation for all youth, but in particular, we've heard of some probation conditions that try to require a young person to be gender nonconforming and really don't allow a person to express their gender identity. So I think that's just like one tiny little piece that's important. But I think that everything that Laura said would apply to probation as well. And I'm be curious, Naomi or Laura have anything to add as well.
This is Laura. The things that I've reviewed, but also just maybe talking as a group. You know, I don't know how many probation officers are in this particular jurisdiction or this office, but getting together to have a training, to talk about ways in which you know, you might feel uncomfortable if perhaps that's the issue, and discussing it, and bringing in someone that has training like Naomi or Christina to talk about ways in which you can effectively communicate with kids and not feel nervous yourself. And then also just being mindful of the message that your office communicates. Again, simple things like signs around the office, even a small sticker. I have one outside of my office here in Columbus, and again at the facilities around the state that I work in. Just small things that are unsaid that may invite a conversation or invite acceptance, and communicate that it's an accepting atmosphere, I think help.
And just one more thing is that I think for all stakeholders, but including probation officer, is to be really aware of the community programs, the programming available in the communities, especially if it's programming that is required by probation, and to understand whether those service providers have had training on working with LGBT youth, if they're competent, if they have had implicit bias training, if they have non-discrimination policies as well. I think that's another important piece.
Okay, thank you. Our next question is, what is the best way to name a youth, or excuse me, what is the best way to address the name a youth goes by when completing legal documentation such as court reports, which typically require that a legal name is used?
this is Laura. I don't know if it's possible in your jurisdiction, to have the legal name, but then also to have perhaps an alias or otherwise known as, to indicate to the court that perhaps on official documentation the child, this is the legal name, but the child prefers to go by, a different name. But just to check with the child, like I said, when you start the interview, what do you like to go by? And sometimes kids are usually willing to share what a nickname is or why they like to go by that particular name. And certainly if it ties back to gender identity or sexual orientation, I think that it's worth having a conversation with the court, if the child will let you, and with other stakeholders about why it's important to address the child with that particular name or pronoun.
Okay, I should mention that I apologize. I left the last letter off of Laura's email address on the last slide. It is GOV. So I will adjust that when we post it, which reminds me that we will be posting this recording and the PowerPoint within 24 hours on CJJ's website. So if you would like to share it with anyone, you certainly can. I'll give everyone just a minute or so to see if there are any other questions. While I do that, I just want to thank the presenters again for joining us, and hopefully we can move forward on this issue. Let me see if there are any other questions. Hold on. Okay, our next question is there anything judges can do to make the courtroom more user-friendly to LGBT?
Sure. Again, I think just like probation and other stakeholders, I think, if there are ways to have, whether it's in the courtroom or in the courthouse, safe space stickers, rainbow stickers, just even a small little sticker on a bulletin board, if there are bulletin boards that, that signifies something. So I think creating that space. Again, if there are materials that the judge is able to have, even if that's out in the hallway. And then I think setting the precedent, I think the judge has a unique position where, everyone's going to listen to the judge, and if the judge is the one saying, what would you like me to call you, or, and using the right pronouns, I think judges can also ensure that defense attorneys, prosecutors, anyone else in the courtroom uses the right pronouns. I think those are just a couple quick examples of what judges can do. And I also think judges should know about community programs that they send youth to, as well as facilities. And if and that goes for all kids, but they should visit all facilities, and they should know how LGBT youth have fared in those programs and facilities.
Okay, well, that sounds like we've answered everyone's questions. I wanted to give the speakers any last-minute thoughts that you wanted to share since we had some time?
This is Naomi. I just wanted to say that I think to Christina's point that around judges and sort of the tone that they set in the courtroom, I think that these improvements not only benefit LGBT youth, that many of the benefits that we've been talking about would benefit all youth. And so even if you don't think that you have LGBT youth that you're serving, asking youth what they like to be called and having judges come from that perspective, I think is a really beneficial thing and something that would help many youth.
This is Christina. I'll just say thank you again, and feel free to reach out to any of us on this topic. And I'm also just going to encourage everyone once more to go to gault@50.org, get involved in the Gault at 50 campaign. There's tons of social media, and to endorse our statement of principles.
Great. Okay, this is Katie again, thanking our presenters for speaking today, and thank you all to our attendees for joining us, and have a great day.
Thank you.